Martha Curtis. I'm a board-certified adoption lawyer with the law firm of Jeannie T. Tate. I'd like to talk about relative adoption. Many times, a relative is called upon to provide care for a child for a lengthy period. Often, such arrangements start out as temporary, but over the passage of time, it becomes evident that a more long-term solution is necessary. Sometimes the parents of the child recognize that the need for care will be long-term because for one reason or another, they are unable personally to provide for the appropriate care and upbringing of their child. Long-term substance abuse, chronic mental health issues, repeated incarcerations, and other complicating factors can impair the parent's ability to successfully parent their child. For many families, adoption by a family member is the best means of providing for the safety, health, stability, and long-term legal security of the child. Parents can sign a written consent to adoption of the child by the relative that they select. Under Florida law, for an adoption by a close relative, defined as a person related to the child within the third degree of consanguinity or blood relationship, no home study is necessary for the adoption. The benefits of adoption are many and powerful. The adoptive parents become the parents of the child, just as though the child were born to them. They are vested with all the parental responsibilities, duties, and obligations for the child, including such things as child support and all other duties that parents have for their children. They also have full parental rights to guide and nurture the child, to authorize medical care, and to provide for the child's upbringing. The birth parents are relieved of these obligations because by the adoption, their parental rights and responsibilities are terminated. The birth parents have the peace of mind of knowing that the child is having the life that they desire for the child. Birth parents, freed of this responsibility for the child, can devote their full attention and resources to their own self-care, rehabilitation, and creation of the productive and fulfilling life they hope to have for themselves. Birth parents need not lose track of how their child is doing. Adoptive parents can provide photos and reports on how the child is growing, achieving milestones, and thriving in their daily life, having the life that birth parents always wanted for the child. In some instances, birth parents whose lives are on track can have future communication and even contact with the child and maintain a healthy relationship with the child. Relative adoptions need not be voluntary. If a parent is unwilling to consent to the adoption, or their whereabouts are unknown and they've not been able to be contacted, depending upon all the facts and circumstances, there may be a basis for the court to involuntarily terminate the parent's parental rights. If the parent has largely been absent from the child's life, or has only been available on a sporadic or unreliable basis, has failed to financially support the child, or maintain a substantial parental relationship with the child, the court may be able to determine that the parent has abandoned the child within the meaning of Florida law. This is a very factually intensive inquiry by the court, and detailed evidence must be presented. Even in a voluntary case, there are many legal issues that may complicate the process, and it is critically important to retain an experienced and knowledgeable attorney to represent you in your relative adoption case. Florida's adoption statute and the case law interpreting it contain very detailed and nuanced requirements, giving rise to significant pitfalls for the unwary. Native American Indian background of the child, diligent searches for a missing parent, putative father registries, all of these involve significant legal issues. Any prior Child Protective Services investigations concerning the child must be reviewed and may affect the venue or county where the case can be filed. Any prior court cases from another state involving the child may affect whether a Florida court has jurisdiction to proceed with the adoption. Lack of jurisdiction is a fatal flaw and can be raised at any time, even long after the final adoption judgment is entered. Permanency for the child should not be delayed or jeopardized due to a misstep by legal counsel. Adoption is a loving and selfless decision by a parent to give his or her child the life the parent wants the child to have but cannot provide. It's also a loving and nurturing decision by a relative caregiver to give a child a stable home, a loving upbringing, so the child can thrive and achieve his or her potential. Our firm has handled relative adoptions for more than 20 years, securing stable, loving, forever homes for children. We invite you to visit our website at floridaadoptionattorney.com to learn more about us. If you have financial need, please don't let this deter you. There are many resources available for private grants from multiple sources, loans, as well as state adoption assistance, commonly referred to as subsidy. We will provide information and resources to put these at your fingertips. If you or a relative believe you may be interested in pursuing a relative adoption, or you have questions, please contact us. We would feel privileged to assist you.